places where the truth's been thin. Sharp tongue firing like a rebel's hymn. Justice served with a snarky spin. Nick's got the mic and is breaking it down. Lego chaos spinning all around. Laughing at the lies at the courts of crown. Riding the edge where truth is found. Coffee's cold but the witch stays hot. Poking at the holes in the legal plot. With a tilt of the glass he connects the dots. The courtroom's wild and he calls the shots. Nick's got the mic and is breaking it down. Lego chaos spinning all around. Laughing at the lies at the courts of crown. Riding the edge where truth is found. Yeah. Electric strums echo through the air. Justice tangled in a legal snare. With a grin, he tears it bare. No nonsense talk for those who care.
Hello, folks. Look who I found.
Hello, hello.
A very, very tanned Dave.
Yes, yes. I've not been spending much time on the internet.
Well, ta-da.
Well, but again, it's Sweden. I mean, it's daytime for like 3 days there.
Yeah.
The sun is out anyways.
Summer, the best day of the year. Well, welcome, folks. Welcome back to the channel. We are getting back to the Michigan hyperbaric chamber explosion case. And, well, the basic facts are that in March of 2025, a 5-year-old boy entered a hyperbaric chamber for treatment for his ADD and sleep apnea. Chamber was filled with 100% oxygen and then was pressurized. Then a spark ignited the chamber, and the 5-year-old did not survive. The CEO and 3 employees are charged with second-degree murder in this case.
Yes.
Yeah. Dave, what have you are quite close.
Yeah, this is in my county. It's not that far from me. From what I understand, the people in charge might have fudged some of the records and the reports and weren't acting the most responsibly. The one thing that was interesting to me is like we're doing oxygen hyperbaric pressurized chamber treatment for ADD, which seemed odd to begin with. It's like one of those like like let's rub some mineral oil on you to cure your cancer sort of thing.
Yeah. I went through that. It seems like the modern day snake oil.
When I first heard this, I thought maybe they were going to bring charges against the parents as well, but that doesn't seem to be the case.
No, it doesn't. It is what it seems to be because this treatment is not covered by insurance or Medicaid or anything, so the parents have to cough up 100% of the cost.
Yeah,
for this, it's not regulated, and so yeah. And this is one out of several hyperbaric chamber centers that is owned and driven by the CEO.
Yeah, and apparently they're not licensed either. Now, there are some, regulations and things they're supposed to do with regard to the chamber itself, but they don't have to get a license to operate, which I don't like licenses to begin with. And so I'm not necessarily worried about that. But
Yeah, but if they are offering medical treatment, all of a sudden you're in a new ballpark.
but here's the thing.
Mm.
It's not medical treatment in the eyes of the state. It's,
Yeah,
you know?
but how are they offering it?
Right.
Yeah.
That's the thing.
Mm.
But yeah, so this is interesting. It seems like they were fudging some information, and you were saying that they I hadn't heard this, but they didn't connect a ground wire. When you have pure oxygen, it's very flammable, and it sounds like there was a stray static spark inside the pressurized unit, and I would imagine that ground wire is kind of important.
Yeah, and in all of this, since it's 100% oxygen and pressurized, all of that oxygen is pressed down in the kid's lungs, and then everything catches fire at once.
It's gotta be horrible experience to have that catch on fire.
Yeah,
And
the mother reached after the kaboom. She reached in and grabbed her child, so she got injured as well. I would assume there's quite a substantial civil suit going on, or at least in the works.
I would imagine if it hasn't been filed yet, it's going to be filed shortly.
Yeah.
But yeah, so we have a hearing from 3 weeks ago. I haven't been following the trial. I've been just following the story in the news. So it'll be interesting to watch this.
Yeah, I got on my Friday stream, I ran out of things to talk about, and this, hey, please, nobody is covering this. Please check it out. So we checked it out, and so we did the arraignment and the first, scheduling meeting, and now it seems to be this is the actual court hearing. Everything is a court hearing, but this seems to be where it actually starts. We will hopefully find out a bit more about the allegations in this one.
Who's that woman standing up? Is that one of the defense attorneys?
The woman who's standing up is, I believe, that's the CEO.
Oh, okay, all right.
Yeah.
I was gonna say she looked familiar. I feel like I've seen her before.
Yeah,
this is the CEO's hearing because I don't see the other defendants there.
So yeah, let's check it out.
All right.
And everybody, welcome.
Oh, I might have mailing address. I was just going to say, I might have a meeting that was supposed to go at 12:30 and is being delayed. So I might have to pop off for a minute.
Yep.
But I'm going to hear this as much as I can.
Yep.
That we have for you on the court file. Yes. Thank you. You can be seated. Today is the date and time that we have scheduled the state's motion. This was a motion that was filed previously entitled Motion for Court Approval of Review Team Process. I did have an opportunity to review a response that was timely filed by the defense. And in addition, after the last court date, the people were able to provide Exhibit A, which had not been attached to the original motion, but the court found it
Who's the judge?
quite necessary to include it. So we received that shortly after the last time.
Maureen M. McGinnis.
Okay.
We were together for court.
Now, in the I believe she did the arraignment and first hearing, and I had complaints in my chat she's stating everything as proven facts already. But in pre-trial, most of the things alleged by the states are considered is in the best light possible for the state. Isn't that correct, Dave?
I mean, it's not so much in the best light of the state. It is whether or not there is
probable cause,
more than a hunch.
Yeah.
Some sort of specific articulatable fact that a crime was committed and that this particular defendant committed that crime. It's a very low threshold. And that's all that this judge needs to find. She is a district court judge. That's what I wanted to look up. So this is still at the district court, has not been bound over for felony charges yet. So we're still in the lower court proceedings. So that's where we are.
And I've had a chance to review that as well. I know that because that was filed after the fact the defense was provided an opportunity if they wanted to supplement their response. And it's my understanding that no additional response was provided. You intend to rely on your original response.
Yes, Your Honor.
Okay. Both of you can place any argument that you like on the record. If there's anything else you would like to add or focus on that you had outlined in your original written motion and response.
Judge, I think I will just briefly.
Okay.
Thank you. Judge, what we have here is sort of an odd situation where I think we're all in agreement that the defendant has rights that need to be protected, and the people's position is that our review team policy does protect those rights. I know we're all on the same page, now, no pun intended with the document. But what we have here is a policy that gives the defendant adequate protections, but still allows this process to go forward. What we have is a policy where search terms are created by both the defense and the government. And unfortunately, the court does have to do some refereeing here. If search terms cannot be agreed upon, then the court, kind of has to step in. Our third-party vendor, which is called KL Discovery, which is not something that was included in the brief, they're the ones who do the search, and they're the ones who essentially control F these documents and find any of the search terms that were either agreed upon by the parties or ordered by the court. And ultimately, Judge, what we have here is a process where the
Hey, Mr. Branca.
I saw the super chat come in. And I was like, "Who's that?" And then, of course, it's Andrew.
Hi, Andrew. Hi, Andrew. Oh, I hope you're doing. I'm seeing on your channel, Andrew, that you're doing quite well. You're doing quite well nowadays. Well, you've been doing quite well for quite a number of years, but now you're doing even better. Good for you. Good for you. I'm happy for you. And thank you so much. Thank you so much. Yours seems like an easy 1 a.m. jazz club catch. She's. I'm taken.
She's lived in Troy her whole life, and well, you don't know Andrew, but what they say about ladies from Troy.
Well, if you go by the Greek dramas, Troy is.
Yeah.
Helen of Troy. Yeah. All right. Let's continue.
defense is getting the first initial opportunity to determine if there's any potentially privileged information that should not be going to the government. And it's only after they make that determination that our review team has a chance to look at those materials. And if there is any disagreement, then ultimately our office, the review team, would file a motion with this court, and this court would be the one that decides the legal question of whether or not a document is privileged. What this isn't, Judge, and I think it's a weird way, but the way to look at how this policy protects the defendant's rights is to talk about what it doesn't do. And this is, I'm expounding on sort of something that was in our brief, is what this document doesn't do, as I said, is give the government the first opportunity to determine privilege. It's not a policy or a process where the government's review team can sort of unilaterally give materials to the investigative team without the defendant having an opportunity to object, or have a say-so. It's not a policy where the government can ignore the defendant's objections. And it's not a policy or a process where the government is performing this judicial function, which is outlined in, I forget my name right, in the In-Re search warrant case out of the Fourth Circuit. There, the court was concerned that the government's review team was performing a judicial function, answering questions of law. In this case, Judge, in our policy, the government's not doing that, because ultimately, if there is any dispute regarding the question of law as to whether a document is privileged or not, this court would be answering that question, not the people. So the people's position is that this policy does adequately protect the defendant's rights, by any legal metric, by the case law that I think we're both citing. The only thing I would add also, Judge, is Mr. Gleason and I are kind of on the same page in that there's no statute, and there doesn't appear to be any case law, state or federal, that mandates that taint teams must be used. But what I will say, Judge, is that during the Flint water investigation, just like in this case, the government's team had luckily not as much as in this case, but a tremendous amount of electronic material. And when we had that material in our possession, the defendants claimed that some of the material may be privileged. And Judge Kelly of the Seventh Circuit Court ordered that a taint team be used, almost exactly to the one that the people are proposing. And an appeal was made with the Court of Appeals. The Court of Appeals denied leave, saying that there was nothing we need to look at with respect to Judge Kelly's order that a taint team be used. And that decision was appealed to the Michigan Supreme Court. And the Michigan Supreme Court, again, denied the application for leave. So I know there's no statute or case that directly says that taint teams must be used or how they should be used, but it's very clear that in that instance, Judge, in a case very similar to this, as far as the materials we're talking about and the privilege concerns that have been raised, that at least one panel of the Court of Appeals and the Michigan Supreme Court has no problem with a circuit court, or in this case, a district court, ordering that a taint team be used. So I think it's clear that in the state of Michigan, this kind of process can go forward without, trampling the defendant's rights. I'm sure I'll have a little bit in rebuttal for whatever Mr. Gleason says, Judge, but unless the court has any questions, I'm happy to have a seat.
No, that's great. Thank you.
Thank you.
You know what I'm surprised you didn't mention? There's actually a proposed court rule change that I think is going to go into effect pretty soon regarding this very issue, and the court's going to allow it. They're not going to name it a taint team, thank God. But the court's actually specifically addressing this issue. I'm surprised you didn't bring that up.
Maybe the defense would bring it up.
Maybe.
Your Honor, I think we are in agreement that the attorney-client privilege is a cornerstone in the state's jurisprudence.
Did he freeze or did I
something
freeze?
that you, before you took the bench, exercised with your clients. I do it every day with mine. And it is there for a reason, and it has been there from time immemorial in terms of what attorneys and how they communicate with their clients and how the clients communicate with the attorneys. The Troy Police Department was notified on February 5th that the items that they seized contained potentially privileged communications between Ms. Peterson and her attorneys, not just me or Mr. Kramer, but other lawyers and other law firms. It appears that despite that, the Troy Police Department examined those laptops and Ms. Peterson's cell phone, because if the court looks at page 17 of the swear to, Detective Trigger indicated to the magistrate that, in fact, further review of the cellular devices and laptops pursuant to the search warrant showed investigators' messages.
Yeah, one of the allegations in this case is that she tried to wipe her laptop.
Oh,
yeah.
I forgot about that. Yeah, you're right.
Yeah, and also tried to instruct some people on site that to erase surveillance video.
But if any of the communication was to her attorney,
yeah,
then that shouldn't be allowed.
Yeah,
the state shouldn't have access to that.
Yeah, we have the big Brian Walsh case now in Michigan. No, in Massachusetts, with the same cops as in the Karen Reed case, where they conveniently forgot everything about search warrants.
Yeah, they sometimes do that. Here it looks like they're doing it the proper way, but the defense has objected, saying there's privileged information in those communications. And so what they're trying to do is they farm these out. I used to do it when I first got licensed. They farm these out to big firms that hire attorneys temporarily to go through documents and code them. And you search keywords and you pull the document out and you say, this is relevant, this isn't, this is privileged, this isn't. And so me as an attorney doing it, I have no idea who the parties are, what the case is, and I have no input whatsoever. I just code everything. And then the stuff that gets through us, and it's like triple checked, and then it goes to the other side. So that's essentially the process that they want to have happened. And I'm not sure why the defense is just saying, no, let's not do that, because they don't want to turn stuff over. They want to be the ones that select what is privileged and what is not, which is understandable. And we'll see what the court has to say.
Yeah.
So they've already looked at them. And this motion comes a little late in that regard because the police department already did it. And that's a problem. And Mr. Kessel also used that information to argue for bond that same day, indicating that information had been found and these are reasons to detain Ms. Peterson. The use of a taint team, I submit to you, is a usurpation of the judicial function. The lawyers don't get to determine in an adversarial case what is privileged and what is not. You do. judges do. The executive branch does not get to review my communications to determine whether they're privileged or not. The
I agree.
proposed Taint team are assistant attorney generals. Those are people hired by Dana Nessel, paid by Dana Nessel, sometimes promoted by Dana
Send it to a
Nessel,
private
but
firm.
they're
That's
in
the
her
option.
office. It's the same office. This isn't some independent group. It's the attorney general's office. And that's not the judicial branch. And yes, I agree that creates perhaps more work for the court, but that's why we have courts, to make these calls as to what's privileged and not the prosecutor. If this were a civil case, would the plaintiff get to decide what communications are privileged for the defendant or vice versa? Absolutely not. There's no difference here because it's a criminal case, and I think even more so here because in a criminal case, one side has a tremendous amount of power, the government. The government has search warrants, administrative subpoenas, arrest powers, none of which a defendant has. And in these scenarios, far more than in a civil case, the judiciary is the one that says to the executive branch, you've gone too far. We come to you with search warrants and say, Judge, you need to decide whether this violates the Fourth Amendment. We come to you to decide whether an interview has violated Miranda and the Fifth Amendment. We come to you to decide whether due process has been violated. We don't go to the Taint team at the Attorney General's office to make that decision because you're the judge. And that's what the people of the state of Michigan and in this district are elected you to do. The Flint water case, I submit, is a misnomer because, as I recall, that case kind of fell apart for the Attorney General. And so it was never reviewed upon a conviction.
It did kind of
interlocutory.
actually.
And I have yet to have the Court of Appeals in any of my cases decide anything for a criminal defendant interlocutory. They wait till the conviction enters and then decide the case. So I think that's kind of, to say they declined to hear it mid-case isn't authoritative. The policy that I got, the court received afterwards, it doesn't exactly work like Mr. Kessel is representing, I don't think. It's not as if this vendor, KL, whatever, gives everything to us to review before the Attorney General's office sees it. That's not what happens. In subparagraph K, there's a privilege team that's assistant attorney generals that makes it determine whether it's privilege withhold, privilege redact, privilege exception, and not privileged. That's the Attorney General making that determination, not me. And then when you look further on, it's subparagraph 01 through 03, the Attorney General's office, the Taint team, can turn over whatever it wants, whatever it decides is not privileged. The only stuff, as I read this, that we get to see is when the Taint team says, oh, maybe this is privileged, or oh, this is privileged. The stuff that the Taint team decides is not privileged goes immediately to the investigative team before I even see it. So not only do we have the executive taking your power away from you, which should not happen, we also have a policy here that's designed that all this takes place before we ever get to see anything. It's not as if they give us all of the material, say, this is what. They only give us a small slice. What they find is not privileged, they turn over. And we have no way to deal with that. But that's...
Wait a minute here.
Sure.
Can you please go to the top of page 8 of 9 under section O, which you just referenced?
Yes, Your Honor.
So section O is specifically outlining the handling of potentially privileged materials designated as not privileged. And you just argued, which is important, because in some of the case law that was reviewed, this was really a deciding factor when you have material that's reviewed and a team that has been developed and serves as the filter team or the taint team or whatever language you want to use, makes the decision in the other cases that certain materials are not privileged and they just turn them right over to the investigative team. That was problematic for one court. And I reviewed Exhibit A and noted under every section, including the section where the materials have been determined to be not privileged, there's still a component that requires that all of that material has to go over to the target or the target's counsel, and a reasonable opportunity must be provided to review and either agree with or object to the review team's designation. And if there's not an agreement after that occurs, comes back to the court. So I see this as even the material that's determined to be not privileged still goes to you and to Ms. Peterson for review before anybody gets it.
I don't read it that way, Your Honor. If the court looks, the review, the categories that the taint team creates is subparagraph K.
Oh, this
Privilege
is Ms.
withhold,
Peterson.
which is supposed to be,
That's
I think,
not the
terms of this,
CEO,
privilege
I
redact,
believe.
privileged exception, and not privileged. In paragraph 03, the privileged team may turn over not privileged material to the investigative team. So under K1D, the privileged taint team, whatever you want to call it, filter team, if they find in their determination, not ours, they can turn it over under 03.
After 1 and 2.
Oh yeah, sorry.
No, because
Just let's see here. The center's founder and chief executive, Tamara Peterson. Okay. Then the facilities manager, Gary Markin. Safety manager, Gary Mosteller. And the operator of the chamber when it exploded, Alira Moffitt. Those are the 4 people. And this is Miss Peterson, who is the CEO.
one only requires the potentially privileged material to be turned over.
Well, and I'm going to let you continue, and I'm sure it's not welcome that I'm interrupting what you have an opportunity to say at this point, but this is important to me, so I want to make sure that I understand this, but I also very politely want to point out that this is part of the reason that I asked if you wanted to supplement
Understood.
your response after we actually got this document, because part of what I'm sure we'll get to here in a moment is that there is case law that specifically addresses the use of a filter team or a taint team. And a lot of the decisions that I saw have been made by the U.S. Court of Appeals really hung on language here. And so this is something that I think we want to all make sure we're on the same page.
Understood. I thought it was clear because here's what I'm seeing in 01 is that the privileged review team sends it to me. So the privileged review team already has it, has already made its decisions among those 4 categories. And that's what the cases that I cited you was the problem. Because the defense attorney is second in line. Even if, again, we're moving past my judicial function argument, but the concept here is, and I think the cases that I cited is the fox and the hen house and what we read there. Here, the privileged review team has the stuff first, and that's the distinction. And that's why as I read it pretty clear, because it's not KL the vendor sending it to us for us to do our review. KL sends it to the privileged review team at the AG's office, and that's the problem. And that's how I read that. And Mr. Kessel wants to say to me I'm wrong. That's fine, but it's the plain reading of the policy, and I think he has to. I think if you ask him, he has to answer yes. We send the electronic devices out to KL. We give them search terms. Then it comes back to our privileged taint team in our office, and from there it comes to us, and that's the problem with the policy. And I think that's the overall problem with all of these filter teams. Again, it's injecting the executive branch of government where the judiciary should be making that initial decision.
Okay.
And again, I don't think, in a civil case, if I were to get interrogatories or requests for documents, the attorney for the party, would do the review. I would create a privilege log. I would send it to the other side. And if they disagree, they would come to you. They wouldn't say, I want to see those. I mean, that's the whole purpose of the court reviewing privilege. So that's why I'm thinking here that the policy doesn't work. And it really doesn't work just because of this idea that you make the decision.
I agree with the defense that
So I
the
don't
court
think what you're
rule,
saying that
the court rule requires that the court conduct an analysis to determine whether or not communication is privileged and therefore subject to an exclusion under the subpoenas. So if we're going to appoint a team of people to go through everything, it needs to be at the guidance of the court, appointed by the court, governed by the court, reviewed by the court, and not the prosecutor's office. Again, appoint an independent law firm. The court could appoint an independent law firm, and that law firm, reports to the court and only the court. That would be the best way to do it, but it's going to come out of the court budget, and that's why they don't want to do it.
Mm-hmm. Okay.
Is that you initially it appeared as though you were indicating that at some point in this policy, when some determination has been made about a subset of the material, there's an automatic right for the privilege team to just release it to the investigative team. I disagree with that. I think your bigger issue is that, your bigger issue really is there should just be no filter team. That's what you're saying.
Correct.
Okay.
If there's a vendor KL, those documents, it's pretty much emails, right? That's what we're talking about, communications, attorney-client privilege. Those emails should come to you. I can't imagine there's tens of thousands of them.
So
it's a small
where
business.
was the case law that supports your position?
The case law that supports my position, Your Honor, I cited in my brief.
Well, the case law that was cited, from the court's perspective, it was really three cases that
Yes.
both of you utilized and took different bits of information and different parts of the opinion to support your position. But if your overall position is the law does not support the use of a filter team, period, in a criminal case, where is it?
I
Where's
believe
that law?
that's the standard, the fact that the judiciary, because I don't think there is a Michigan case, Your Honor.
I think this is a bad
We
argument.
cited federal cases. In the U.S. Attorney's Office, I will concede federal prosecutors continue to use taint teams. And I'm arguing under the Michigan Constitution as much as the federal. This is a judicial function.
I 100% agree with that. So that isn't something that you have to convince me of.
Right.
But ultimately, the process in which the court maintains its judicial function seems to be what is up for debate, I think, at this point.
Here's, if I may, Your Honor, what
Yes,
I
of course.
propose. The use of a vendor, the vendor's going to get used no matter what. Someone is going to go and figure out where the Varnum or Miller Canfield emails with Ms. Peterson are. The question is, in my mind, who gets to review those first? And I think if we're going to use a taint team or if we're going to use something, we get to review them first because it's her privilege. And this policy doesn't allow that. The only thing they give us are the potentially privileged materials.
I think the notion that's a little bit difficult for everybody to wrap their head around is the court's not being asked to pick between Mr. Kessel or Mr. Gleason to review the potentially privileged documents because I couldn't. I couldn't pick one of you over the other.
Right.
That would simply be unfair. I think what we're struggling with is the notion that the proposed filter team is comprised of attorneys that work for the Attorney General's office. But I think it would be a little bit unfair to say that the proposed policy as it's been presented to us doesn't make, I think, it very clear that it's not to be anybody that is a part of the team that is working on this case. Yes, there are going to be employees or attorneys of the Attorney General's office that would be identified and would serve on the filter team if the court approves it. But I feel like, for argument's sake, there's an attempt to appeal to the general sense that the court would approve a filter team like this, and I'm essentially letting the Attorney General, Mr. Kessel, make the decision on privilege. But I think it's really a little bit more nuanced than that. I need to see a policy, a proposed policy or protocol that clearly identifies, to the extent that it can, that anyone that would be involved in this process after the vendor culls all of the discovery and gives whatever falls under gives the discovery that falls under the parameters with the search terms, and they review it, but they would be separate from your side or Mr. Kessel, really. So I think I really would like to hear Mr. Kessel probably focus a little bit more on that, just so we can have a record.
Understood.
And I understand your position very, very clearly. But I just think in general, I want to hear Mr. Kessel argue to the extent that he can what's in the proposed protocol that is identifying a separate and distinct body that would review the information that comes from the vendor and make it very clear to the court, if he wants me to consider what's proposed, that it will be not one single person that is involved in this case or is working on this case or has worked on this case or may work on this case, because I think that is the key component here. And I worry that when the argument really centers around, well, Judge, you're just going to give it to the AG's office to review everything and make the decision. I just want the record to be very clear that it wouldn't be just turning it over to Mr. Kessel to review everything. No. My expectation is it is a completely separate and distinct body of attorneys that would be doing that. And the defense hasn't proposed anything that I could consider from their end.
Helm Law will happily review the documents, Judge. Helm Law can handle it. Send it right over. I mean, throw a stone and hit a law firm, Judge.
Yeah, Judge, we have somebody here who gladly will take the hourly rate to review everything. Yeah, but my issue here is, now this might be a bit simplified. The state is the state is the state is the state. The AG's office is one entity. It's
I gotta
the government.
Run. Sorry.
Okay. Yeah, no worries.
All right. See you guys.
Yeah. See you. Yeah, Dave had a scheduled meeting at 12:30 that was postponed, but apparently now it's going. So yeah, my issue here is, well, even if it's still the AG's office, even if she says we have to separate these people from the case, they cannot work on the case, but it's still the state. I would be more comfortable if these things were handled by a third party that isn't connected to either the defense or the AG's office. Let's keep listening.
I proposed to special master or the court to just review those emails that are determined to have come from Farnham or Miller Canfield. My view is if we're going to allow a privilege examination to occur, right, that doesn't involve the defense counsel or the prosecuting attorneys, it should be someone who is neutral, impartial, and uninvolved with the process. And my view of the world, and I have the utmost respect for Mr. Kessel, but the decision you're making here, because we don't have one in the state of Michigan really, isn't just going to apply in this case. This is something the court looks at in terms of every prosecutor's office, the attorney general, county by county. And to me at least, the review of what's privileged or not, the first person who should decide whether to raise privilege, because there are certain instances like advice of counsel where you might not raise it, but that initial decision should be made by the holder of the privilege. I think that's what my argument is.
Okay.
Thank you.
Thank you.
Judge, I think maybe the better focus might be looking at section H sub 1 sub A, which is on page 4, where after the search terms are agreed upon, and again, that's something that Mr. Gleason and quite frankly, the review team in my office is going to hash out. I'm not even a part of that. And again, if we cannot agree on search terms, then again, unfortunately, this court would have to kind of come in and play referee. But once this court orders those search terms are put in place, those are the terms that will be used to look through, like I said, sort of control F these documents. And what the policy says is that materials over which the target or target's counsel claims are potentially privileged material. That means anything that hit, right? So any document that contains any of the search terms that either we agree upon or this court orders, those are potentially privileged documents. Anything that hits as potentially privileged goes to counsel. And material over which the target or the target's counsel do not claim the privilege or are not potentially privileged may be turned over to the investigative team. So anything that does not include any of these search terms, yes, that goes to the investigative team, not because we decided it or not because counsel decided it. It's because those documents simply did not include any of the terms that ultimately this court may have to decide may include some privileged material. Once there are potentially privileged materials, i.e. anything that hits on any of the search terms, counsel gets that, okay? And at that point, Judge, this court makes rulings of law on argument all the time. The government will come in, whether it's the city attorney, the Oakland County prosecutor's office, my office, we come in and we say, hey, Judge, this search was legal and here's our position, or this questioning was legal and here's our position. And defense counsel, whoever it is, comes in and they take a position. And ultimately, this court decides the question of law as to whether or not a search was valid, a statement was good, rights were violated or not. And that's all that's happening in this case is the review team in my office and counsel review this set of potentially privileged materials. And in most cases, I imagine there probably will be a lot of agreement on things. Where there's disagreement, my office's review team takes a position, defense team takes a position, and nothing happens until this court orders it.
All right. Yeah. The number of viewers have slowly risen. So the elevator pitch of this case is that in February of 2025, a 5-year-old boy entered a hyperbaric chamber for treatment for his ADD and sleep apnea. The chamber was filled with 100% oxygen. Then it was pressurized. Then a spark ignited the chamber and the 5-year-old did not survive. And since the chamber was pressurized, that means that 100% oxygen was all the way down in his lungs. So when this caught fire, all of him burnt at once. And the state alleges that this was due to by neglect from people within the company that had this hyperbaric chamber, such as they turned back the dial on the service. For instance, in this case, 20,000 cycles, and then it needed service. And according to what we heard in the arraignment, the staff have pushed that back since at least 2022. And also the allegation is that one of the employees tried to service it and repair this chamber himself. And another allegation is that when this happened, the ground cable was not attached, which caused this probably static spark to ignite everything. So that is the case. The CEO of the company is charged. The facilities manager, the safety manager, and the operator of the chamber. So 4 people are charged with second-degree murder in this case. Yes, these are pre-trial motions. This is very, very early in the case. Even though it's 5 months in, it's very, very early into this. They are still, in this case, here now. They are arguing about search term in the CEO's devices. What are considered privileged and what isn't. The state has a separate entity, a separate company, the third-party vendor that does this. Now the defense and the prosecution has to agree on what search terms to use to filter out possibly privileged information. So this is the argument surrounding how that process moves along. The defense have written a motion that we have issues here. The state has no issues, and it's up to the judge to decide. Hi, Daria. Hadn't heard of this case before. Going down the rabbit hole. Oh, there's a lot of stories and newspaper articles about this case. Not so much YouTube analysis, because it happened, and with many of these cases, this probably won't go near a trial until somewhere in 2026. So that was the elevator pitch on this case.
So I think that's the step that this court recognizes, and I think Mr. Gleason is kind of skipping over, is nothing that is potentially privileged goes to me without either a stipulation with Mr. Gleason and my review team or this court's order. Nothing goes to us that they claim is privileged until you order it, Judge. And then, as you correctly pointed out, that's the difference between our policy and the policies that were in these cases, right? In the Fourth Circuit case, the government review team said, okay, well, we'll look at everything and we'll decide if privilege applies. And before the defense has a chance to raise an objection or claim a privilege, we're just going to give it over to our investigative team. And, the Fourth Circuit rightly said, no, you can't do that. You're not the arbiter of privilege, right? Because in that instance, the prosecutor's office is performing a judicial function. The prosecutor is not just taking a position on the law, but is really making a ruling on the law as to whether or not privilege applies, and then immediately giving the documents to the investigative team. Obviously, that's not what's happening here. So the fact that my office will argue that something might not be privileged doesn't mean we're performing a judicial function any more than it does a prosecutor's office taking a position on any other question of law. We would have an argument, Mr. Gleason would have an argument, and this court would be performing that judicial function, answering the question of law. Judge, as it relates to that other case, in re grand jury subpoena, the Sixth Circuit case, again, we have a government policy that is very different from the one that we are proposing, in the sense that in those cases, in that case, the government was proposing, we will do the initial review, we will decide what's privileged, and we will be sending our things to the investigative team. Again, Judge, that is not what's happening here. And in fact, the defense in that instance proposed a policy very similar to what we're proposing, which was that a separate party perform a search, the search terms that are agreed upon or court ordered, anything that hit would be given to defense counsel. Defense counsel looks at things. Defense counsel lets the prosecution know what their position is. Prosecution takes a position, and any conflict would be decided by the court, which is exactly what the people are proposing here. And Judge, what I would say is I would add, and I think the problem is, and Judge, I think you kind of note it, Mr. Gleason's position seems to be that, taint teams are unfair and unreasonable as a blanket rule. And Judge A, we know that's not true by the case law, right? But also conflict walls exist all over the place, Judge. I'm sure there are plenty of conflict walls in Mr. Gleason's firm. Lord knows there are a million in my office as well. We get emails about them all the time. Conflict walls are a regular part of doing business in the legal world. That's just how it is. And Judge, to that point, what the Sixth Circuit said regarding the taint team, and I'm quoting here, government taint teams seem to be used primarily in limited exigent circumstances in which government officials have already obtained the physical control of potentially privileged documents through the exercise of a search warrant, which is, of course, what happened here. Continuing in my quote, in such cases, the potentially privileged documents are already in the government's possession, and so the use of the Taint team to sift the wheat from the chaff constitutes an action respectful of rather than injurious to the protection of privilege. So there we have, Judge, the Sixth Circuit saying that in instances where the government is already in possession of electronic material, just like in this case, the process of a Taint team is not only completely legitimate, but also recognizes and protects the defendant's attorney-client privilege, which again, I think we all agree is of paramount importance, Judge.
Sorry, Atheist Dad. Thank you so much. Thank you so much. Saying, I've been lurking a lot due to work. I haven't seen Mr. Jingles. Is he okay? Yes, Mr. Jingles is fine. Mr. Jingles is fine. He is outdoors a lot now during summertime because, I mean, all the farmers are working their fields, scaring up all the mice and rodents and stuff. So he's working. He's working outdoors. And he comes in once in a while and shows me what he's been working at. So in the house, the past month or so, there's been dead mice, dead rodents. Yeah. So I know he's performing his duties. Simone Miller, Nick, could a hyperbaric chamber be like a med bed? No, a hyperbaric chamber is an enclosed sphere of sorts. I believe you are thinking about an oxygen tent. That is different. An oxygen tent is more or less plastic over a bed, and then they pump in oxygen. This is a hyperbaric chamber, which means they fill it with oxygen, and then they put pressure. For instance, you hear a lot about pressure when you go underwater. You have this and so many atmospheres of pressure, the further down you go. That is what's happening in a hyperbaric chamber. They increase the pressure. And lady honestly did not know these chambers existed for ADHD. It's a completely unregulated business. It's not approved by, I don't think, any government health inspector thingy anywhere in the world. So, yeah. Unregulated, not covered by insurance, not covered by Medicaid. And it's expensive, very expensive. And to me, businesses like this are more or less preying on desperate people, the rich and desperate people, in my opinion. Now, if somebody feels they are getting helped by these, good for you. But in this case, they seem to have, according to the state, they seem to have performed their own services on the chambers, ignored safety protocols, and all around screwed up.
Hello.
Hello again.
Hello again. I have. Today has been a day.
Oh.
It's been a day of like running late for everything. What did I miss? What did I miss?
Well, they are more or less arguing around each other. There's really nothing new the past 15-20 minutes. They're still arguing.
What's interesting? What's interesting in Michigan is that in the criminal context, there's not a lot of discovery. Well, there's not a lot in the district court. You can't compel discovery. At the circuit court, you can, but not at the district court. And then even at the circuit court for felonies, there's no, like, you can't take depositions and things like that. And there's not a lot of this discovery practice that you would have in civil cases or you would see in other criminal courts throughout the country. So the fact that there's no rules regarding discovery masters or taint teams or whatever you want to call them in criminal is not unusual for Michigan. We usually don't allow it anyway. And the court is there as the arbitrator. But it sounds like the courts want to kind of get away from it, but they don't want to pay for it. So they're going to let the opposition see the information that the defense is trying to keep out of the opposition's hands. It's nonsense.
Mm. Now, she could make a ruling regarding the prosecution has to present the people in this taint team, and these under no circumstances can talk to the others. But again, as I said when you disappeared, the state is the state is the state is the state.
Yeah. Now there are rules like we've had to follow in criminal cases where my firm, when I had multiple attorneys, would represent various defendants and or witnesses, and we had to, it's called screening. We couldn't talk to each other about the case. We couldn't, fees couldn't be, exchanged. Everything had to stay separate. But it's a weird slippery slope because everybody knows that you're in an office, the same office. So if it's not good for the defense, why should it be okay for the state?
Yeah. And everybody, this is Mr. Jingles. If you're new here, Mr. Jingles, this is his channel. I'm just the face of it. He runs everything around here. Hello, Mr. Jingles. Hello. So yeah, we haven't. It's the defense and the prosecution here, I believe, are talking more or less about the same thing, but they still want the judge to rule for their point of view.
Mm-hmm.
When the when the court talked about the government's proposal, which was sort of like what Mr. Gleason's saying was problematic, the court said that the problem is that appellant's attorneys would only have an opportunity to assert privilege only over those documents the taint team has identified as being potentially privileged. But Judge, again, that's not what's happening here. The search terms that are either agreed upon or are court ordered, that's going to be the determining factor as to what documents are potentially privileged or not. It's not someone in my...
I don't think that is correct, because that is not, you cannot cover 100% with search terms. Now, I would assume that they will filter out email address. This is the attorney's email address. And then the name of the lawyer. And certain, I don't know, defense attorney jargon. I mean, I have no experience surrounding this.
So what we had done in the past was we would be given a list of search terms. And so if the defense provides a list of, say, email addresses, names of attorneys, first name, last name, names of support staff and things like that, as well as support staff emails and whatever. There could be, 200 particular words and or names that are listed. And then what you do is you go through, there's tons of software that does this, and it automatically flags certain documents that contain this. So if there's a paralegal whose name is Mike Wienerholder, anytime the name Mike comes up, it's going to flag that document. This might be Mike Wienerholder. And, so let's take a deeper look at this document and see if it actually is privileged. That's how that's how these software systems work. So you got to come up with the right list of words, phrases, names, and things like that.
My office or someone in Mr. Gleason's office. It's these terms that determine privilege. And then once something is potentially privileged, anything that hits is the universe of potentially privileged stuff. That's when, if there are disagreements, this court has to step in. The court's absolutely right. I have nothing to do with it. I haven't seen any of these materials. I get what comes to me after either our review team and Mr. Gleason agree or after this court orders anything. So I hope I've kind of answered the court's questions, and I know seems like some confusion about how this process works. So unless the court
No,
happy to.
I'm familiar. I just want the record to reflect.
Absolutely, Judge.
Right, but I think it's appropriate for any case, but also in a case where there's a lot of attention that's being paid. I don't want there to be lack of explanation on the determination that is being requested as to who will review these potentially privileged documents. It's not just as black and white as the defense or the prosecution. And so that's what I was just asking you to speak to. But I think I understand the process, and I've spent quite a bit of time reviewing the case law that I think applies here. So thank you for placing that on the record. Was there anything else? I did see Mr. Gleason looking like he wanted to respond. I'm not sure how appropriate that is, but I will give you an opportunity just to weigh in on anything that was added to the record from the last argument.
Yes, Your Honor. And the cases that we cite about the filter team from the federal jurisdictions, they use the grand jury process. And so those are filter teams that are pre-charge looking at documents, where you may get documents from a witness or whomever, and maybe there's no adversarial system in effect there. Here, the case is already rolling, so we have an adversarial system. And if Mr. Kessel is correct that I get the documents first, why do we need a taint team at all? Because I can say, Mr. Kessel, I believe documents A, B, C, D are privileged. Let's take them to the judge and she can decide. Why do they get to look at them at all? I don't understand why they get a chance to see that when it's you who decide when we say it's privileged. I mean, I go back to my civil law analysis because adversarial cases are adversarial cases. And if there was a plaintiff here and a defendant here, and the defendant said, I have privileged documents, you're not going to say to the plaintiff, okay, wall off part of your law firm, take a look at them. You're going to say, show me the documents and I'll make the call. That's all we're asking you to do here is if in fact I am going to get those documents, I can say they're privileged. I can send them to you. You can look at them. You can either agree or disagree. But they don't get to take a peek. They don't get to do that in a civil context, and they shouldn't get to do that here. Because I'm hearing Mr. Kessel say, I get them first, but why do they get them at all?
Well, that would be the first that I'm hearing about anything related to how they obtained these documents. And this was something else that I really paid close attention to in reviewing the case law. There is a distinction in the way the courts are ruling, and they specifically look at who has the documents. The people have the documents already, and it's my understanding that they've obtained the documents as a result of a properly executed search warrant. So that's not, you can't debate that right now because that's not part of this motion. If that was part of the motion or the argument that was going to be made, this would be a whole different conversation. But
Right.
When I get the motion that I've received and the response that I have received, there's no indication that we are arguing the validity of the search warrant at this point.
I agree. That's a different issue.
Okay, so I don't want to go there. Obviously, it sounds like you don't either, which is good. But I do think there's a distinction in the way the law is applied in these cases because the government has these documents. I'm not making a determination right now that Ms. Peterson has all the documents and I'm forcing her to turn them over to the Attorney General's office. They have them and they obtained them through what appears to be a properly executed search warrant.
An unchallenged at this point in time search warrant, I guess, would be the best way to phrase it.
And I know that you mentioned early on in your argument something to the extent of, once we get to is it privileged, is it not privileged, then we get to who reviewed it, who looked at it, how it was considered. That's July's agenda, actually, from what I understand. So
Yes.
I just want to get through June so that we can get to July, quite frankly.
And I think at some point I'm probably making a record. However, I think when the court rules, and I'm getting the sense perhaps the court might be ruling against me, but that's okay. I think the court has to issue an order that tells us what.
I'm texting as you in your chat.
Because we seem to have different opinions about that policy. So I think the court might have to put in its order, this is how it's going to roll, I think is what the court should do, not just
Grant the motion.
Correct.
Well, so I thought about that again. Why I was hopeful that once we actually had this detailed, lengthy policy or protocol, proposed protocol to look at, that there would have been an ability to have some thoughts on if the court determined that it would be appropriate for a filter team to be utilized, is the language that's in this policy something that the parties agree, or there should be an alternative? I can do that. I mean, I can clearly go through and indicate if there's any language in here that I feel should be different to comport with what I think the case law states, or in this situation, if you believe that there's something that you're not in agreement on in terms of how the terms of the proposed protocol read or would be executed.
May I suggest this, Your Honor?
I'm happy to weigh in on it.
It sounds like the court is going to allow the Attorney General to use the Taint team. I don't want to say I'm prejudging the court, but I'm getting the sense I've appeared in front of you for a long time. Perhaps Mr. Kessel and I can propose an order to the court as we would in under a 7-day or something like that. And if there's any portion of the order that either one of us disagree with, we can file our objection.
He's punting it
But
down the
that way
line.
we can write the order.
He
And
sees
as I
where
think
it's
the court
going.
encourage us to do without waiving my objection. It can be noted, and we can try and
I think he got caught. He
I
should
try to
have
make less work for
challenged
the
the
court.
warrant.
Yeah.
He should have challenged the warrant. I didn't know he wasn't challenging the warrant because that's where I was immediately assuming, like everybody knew he was challenging the warrant, and now he's not. But he wants to preserve his objections to the warrant.
Yeah, and he put the cart before the horse.
Yeah.
And
you can keep everything. Just give us our privileged communications back. Yeah, this should have been a warrant challenge.
yeah, because with a warrant challenge, everything is stayed until it is actually resolved. That buys him time to refine his argument regarding this Taint team issue.
And here's the thing. So when we do discovery in civil stuff, we can ask questions about things that aren't necessarily admissible to gain information that we can then go get admissible information. So if they're reading an email from the attorney or to the attorney that says the grounding cable broke and we never replaced it. Okay, so they can't use that statement, but now they know where to look for the information that they can use.
Yeah. Yeah, had he challenged the warrant, he also could have interviewed everybody involved to find out, okay, what haven't they looked at, and now he can go in and challenge the Taint team.
Yeah.
Well,
Recognizing where I think the court is going.
I think it's still appropriate for me to make a decision on the motion in general.
Right.
I reviewed the proposed policy, and to the extent that any of the language included in the proposed policy or protocol, I should call it, is
just a clarification here. We are not putting this is pure technical, judicially things. This is something regardless of the case. They should have done this, that, because I mean the case in itself is absolutely horrific. This part is pure technical jargon.
It is. It's very much. I mean, this is fundamental rights, constitutional, legal issues that would be in effect with any criminal case outside of the facts of this one.
Yeah.
Using, or there's some disagreement on how it would actually be implemented. I didn't really have an opportunity to weigh in on it. It appeared that the parties were taking very opposing viewpoints, that the people believed that the filter team is an appropriate way to address the issue of potentially privileged materials that were seized pursuant to the search warrant, And the defense is taking the position that under no circumstances was this something that the court could approve. So I didn't get into the details of the proposed protocol. I think in terms of issuing an opinion on whether or not a protocol can be established to address the potentially privileged material, I'm in a position to rule on that today. I guess what you're asking is if I'm telling you that this is a protocol that the court is going to require to address the potentially privileged material, do you want an opportunity to weigh in on what that should say? I'm not sure what you're asking.
I guess, Your Honor, what I'm hearing is that the court is not going to order the relief I request, is in that the documents come to the court and the court exercise its authority to determine whether they're privileged or not. In that case, what I'm hearing Mr. Kessel say to the court is that I get the results of the searches by this vendor first before the privilege team or Taint team gets to look at anything, and I get to make or Ms. Peterson gets to make the determination as to what we believe is privileged or not. That's what I'm hearing Mr. Kessel say, and that's, I guess, where I'm trying to find out what happens next.
Okay. Is that what you said, Mr. Kessel?
And Judge, what I'll say is part of the policy is also that there will be timelines that will be agreed upon. So, for example, if Mr. Gleason, we've got the potentially privileged documents, right? And then, okay, we have X number of days to go over these documents. And there is, in the policy, it says, it's agreed upon that you can do X number of pages like per hour review, right? Because what we don't want is a practice where, okay, well, we have this review team, but it's going to take a year for everybody to go over everything, because that's not practical and that's not in the interest of justice and all that good stuff. So what we have are timelines that are set in the policy where we say, okay, this amount of work is going to be done at this point. So, the process keeps moving. So if that kind of answers the question. But yeah, Judge, yeah, Judge, I think that's the people's position. I don't know if I'm really in a position to negotiate a department policy as far as particular issues that Mr. Gleason may have. I think ultimately the question is, does this court believe that this policy adequately protects the defendant's rights? And if it does, then, we ask the court would adopt it.
Okay, so in Michigan, because we don't use grand juries very often, if ever, we have what's called paper filings or paper pleadings. So the prosecutor will file a complaint, and then at the district court level, so the local city court level, they will hold a preliminary examination to determine whether or not there is probable cause that a felony was committed and that this particular defendant or these particular defendants committed that felony. Once that's determined, then it gets bound over to circuit court and the process starts over again. And we have a bunch of discovery and motion hearings and things as we're waiting for trial. Now, where we're at now is at the district court level. There hasn't been a probable cause or a preliminary examination hearing yet. Before that happens, the state wanted a bunch of documents because they have to show a willful and wanton disregard for the likelihood that the actions of these defendants could cause death or great bodily harm. So that's why they want these documents, to show that they took shortcuts, that they jury-rigged a thing, that they didn't have it properly inspected. Whatever they want to show, they need these documents to do that. So we're arguing over discovery at the very first stage. We haven't even gotten to the felony charges yet. So this case is going to go on for a while, especially if there's thousands and tens of thousands of documents that need to be reviewed before we even get to the next level, which is where these people are formally charged with a felony. So we're very early on in this case. Hopefully that explains some things.
Yeah, I said it earlier. This is very, very early. This isn't going to trial until late 2026.
This was charged in
March.
April, May.
They were let's see here. The arraignment was just a few days after the event.
And when was that?
So this was late February, and the arraignment was
March.
early March.
So
And
I
then
would say at the earliest, we'd be looking at maybe January 2027 for a trial if this went all the way through.
Yeah, so this is another one of these cases where I'm in it for the long haul.
Yeah.
I mean,
Although I have a feeling, just knowing the nature of criminal practice in Michigan with the Attorney General's office, that this is probably going to result in a plea for at least a couple of them, if not all of them.
Yeah, I mean, it depends, because there were allegations against the CEO that she may or may not have told the employee to take shortcuts. So that would mean that...
And that's the thing. It has to be willful and wanton. So if she's working with wrong information because she was deliberately deceived, then it might not be willful and wanton, right?
Yeah. So, and that goes both ways. Maybe the service guy, let's say,
made recommendations, and the CEO said
made recommendations. Yeah. Then she might be off the hook, or if one of the, say for instance, the safety manager was ordered, then he can testify against the plea deal. So will be a lot of that moving around, I would assume.
So Neo Dark Matter wants to know if the DA would give the workers a deal and trade on these communications. Well, the communications are going to get out regardless. But if you want somebody to testify against another, usually you have to offer a deal. But here's the thing. What is their motivation? Do they want to go after the CEO because they're concerned about the other facilities in Michigan that the CEO is running? If so, then they'll go to the low-level workers. If they think the inspector or the one actually operating the chamber was more at fault, then maybe they give a deal to the CEO in exchange for testimony against the others. I don't know. Yeah. I don't know what the goal of the prosecutor's office is.
No, I think at this point in time, I think that even the prosecution is trying to find out, okay, what actually went on in there.
Yeah. I think they probably want to know that too before they decide who's going to get a deal and who's going to get pressed on these charges and that sort of thing.
Oh, interesting question, Tim. What punishment would Paolo Macchiarini have faced if he had committed his crimes in Michigan? That is the Paolo Macchiarini. That is the pig throat guy who he did experiments in the Swedish hospitals on patients with throat cancer and other alignments, and he surgically removed throats and inserted plastic tubes, pigs' throats. And over here, he didn't really get much punishment.
Well, what was the unlawful conduct? Was it not with consent, or was it animal cruelty?
Experimental practices not approved by anyone. It was he experimented on humans.
If they did it with consent, if the patients did it with consent, he might have just lost his license. I don't know enough about the facts. Yeah,
the problem is that the hospital is to this day still protecting him, claiming he did correct, while all the people who died, the families are a bit upset. Yeah. They may or may not have been told, they may or may not have not been told this was pure experimental.
Yeah, see, so that's the thing. If he's misleading them, then he would have gotten. I mean, especially if people died, right? Yeah. So then, second degree in Michigan could get you life. These people are facing possibility of life, 25 to life, anyways. So, if he was found guilty of second degree unaliving, then it definitely would have been 25 to life.
Let's see here.
Yeah, you definitely need informed consent on a patient.
Research fraud, I believe the thing was here.
Yeah, I don't know what it would be. I mean, they could easily charge him with second degree if the state pushed the issue that it was
Yeah.
extremely dangerous without
Yeah, okay.
sort of the scientific background.
In Sweden, they opened an investigation, involuntary manslaughter, and
Involuntary would have gotten you
but also that a crime could not be proven because patients might have died under any other treatment.
Yeah.
But in 2019, he was sentenced in an Italian court because he did this on several hospitals, convicted him to 16 months for forging documents. But then the Supreme Court acquitted him. So, yeah, he no punishment.
He faked results and approvals.
Yeah.
I mean, you definitely lose your law license. You probably go away for like 5 years minimum, probably. I mean, I don't know enough about the facts. So something along those lines.
Simon Miller, hi. Was his hyperbaric chamber given a patent? I would assume so because they bought in these chambers to these facilities.
Yeah, they purchased the chambers from a supplier.
Purchased or leased.
Yeah, something along those lines. But they didn't maintain them, is the allegation, properly.
Yeah. They forged the maintenance records or some of the allegations.
And the biggest thing is not the hyperbaric chamber or being under pressure or anything like that. It's the fact that it was pure oxygen, which is extremely volatile. And because the hyperbaric chambers allegedly were not grounded properly and not maintained properly, it caused static electricity to build up inside, which sparked the fire.
Yeah.
And if they had been properly maintained,
it would not have happened.
Even with the spark, maybe it would have been a products liability case instead of a murder 2 case.
Yeah. I would assume that when or if and when a wrongful death suit is filed, they will go after everyone, including the manufacturer.
Yeah, the manufacturer is probably going to get sued, but I would fall back to maintenance of the machine. Like, hey, we produce these things, but we also say that they have to be inspected and checked and repaired, and if they didn't do that, that's not on us.
Yeah.
I guess I'm struggling with your interpretation as well, Mr. Gleason, only because it appears as though what is being requested would, I'm not sure, it sort of negates the whole point of having the filter team. My understanding of the way that this proposed protocol would work, both sides, meaning Mr. Hessel, Mr. Gleason, his client, the other attorneys that are working with Ms. Peterson, they have an opportunity with some sort of time limit, because I'm going to go out right now and tell you this is something that I should have seen in March, quite frankly. And I'm a little bit frustrated about that, but I'm happy we're having an opportunity to fully explore this issue so that I can make a decision and nobody comes back at a later date and said that there's now a fatal flaw to the case because we didn't go over it. But that being said, my understanding of the proposed protocol is the two sides together are going to work to develop a comprehensive list of search terms that they believe, if utilized, will have the potential of catching any potentially privileged communication that your client had with attorneys leading up to the seizure of these devices.
Right.
And both sides get to weigh in, and I don't care how many search terms are on there, quite frankly, as long as both sides have an equal opportunity to weigh in and provide what they believe would be appropriate. If the two of you can't agree, or the two sides cannot agree on whether or not a particular search term should be included, you come back to me. I have the responsibility of making a decision, which I think is a responsibility that I will maintain on this issue until the case is over here, quite frankly. So I don't see any part of this as a decision that I would make today that would relinquish my duties to somebody else. So come back. We will argue about the search terms. I'll make a final decision. Once we are confident that we have a complete list of search terms that will identify any potentially privileged communication that may have taken place between your client and her attorneys leading up to the seizure of the devices. It goes off to a third-party vendor. Clearly not somebody that's involved in either person's office in any way, shape, or form.
Good ruling, Judge.
What they do will be somewhat
Yeah.
monotonous. It's going to be data. It's pulling data based on these search terms, not even something that you're going to have a number of individuals like laboring over to determine. Once that information is produced, however, my understanding of the protocol is that it goes to the filter team, not to the defendant. Because if it went to the defendant to identify what's potentially privileged or to put it in all these categories, then I'm not really sure what the point of the filter team would be. And I'm still planning on issuing my actual opinion on that. But it goes to the filter team. And then the filter team has to work through each of the categories to make a determination. But at each point in the proposed protocol, whatever category it is identifying a potential document to fall within, there is a process that once the review team or the filter team or the taint team makes the determination, it goes over to you to look at it, review it, say, yes, this falls in this category. No, this doesn't fall in this category. We don't agree with you. We're going to take this one to the judge, and the judge is going to review it and make the final decision. So that's my understanding of how everyone would be involved in this process. I understand that the preference, of course, would be for Ms. Peterson, that once the third-party vendor gets all of these documents, gathers them pursuant to the search terms that you've put together, everything just goes over to Ms. Peterson for review. But I don't think that's what the review team or the taint team is put in place for. So I didn't expect that would be the outcome. And I don't think Mr. Kessel is saying that's what the policy would require. But I still find the safeguards that are necessary throughout the policy in that both parties are coming up with the search terms. And there's no limit to what you can put in there, quite frankly. And if you don't agree, I'll make a decision. A third-party vendor then identifies anything that could fall within that potentially privileged category, any of these categories. And once that information is provided to the separate and distinct filter team that is separate from the Attorney General's office, that is actually any attorneys that are working on this case, and they determine what category it falls within, at that point, Ms. Peterson has the ability to review, object.
All right, Dave, you got to run.
Yeah, sorry to be on and off, but I appreciate you having me. And
Thank you for being here. But since you actually work in this jurisdiction, I mean,
yeah, tomorrow night, Nick is going toe to toe with Steph the alternate, guys. Go build off. Don't miss it.
Yeah, that will be after the Friday, slightly buzzed Friday Law Show, where we've watched the final part of the Turtle Boy win in court last month.
Nice.
So I will give Steph a good 6 to 8 shots head start. she will need it.
Yeah, and if you guys don't know who Steph the alternate is, you guys are missing out. She covers a lot of royal news out of England. So this is 1815 again with Sweden versus the UK. The only time they were in a war, apparently, until tomorrow.
Yeah. So I have the Lego here. I haven't even opened the package, so I hope they sent me the right one.
Nice.
Yeah. So me and Steph are going to compete in building Lego tomorrow at 9 p.m. Eastern Time. And and it's a rematch because last time she cheated and started before me, an hour before me. No, I think it was less than a minute apart on that Lego.
It was. And we were doing stopwatch, so I don't trust that. We need to go head to head.
Yeah, we need to go head to head. And so 9 p.m. tomorrow, after my slightly buzzed Friday Law Show, it's going to be the battle between Vikings and their victims. Britain. Yet again, 1,000 years later, Britain.
1,000 years.
Yeah.
All
So
right.
yeah.
See you guys.
Yes. Yeah, it will be a Lego race. Yes, David. That will be tomorrow. But thank you for showing up, Dave.
No problem.
Yeah.
Take care. Bye bye.
Yeah, you too. You too.